All right. It is Tuesday, November the 13th, 2020, and it's about 8:35 p.m. Central Standard Time. Welcome to week number two, two of constitutional law. And I had to stop a minute because I got two classes I teach. So yes, so it's constitutional law tonight, and it is good to see you guys here again. And I see usually the same people. Uh, yeah, the weeks do go fast. Yeah, that's right, Chris. Absolutely. Yeah, that's for sure. You should know. You've been in several of my classes, right? And they do go fast. And I do want to say to you guys, though, this is a very interesting time to be in constitutional law. Engaged in taking a course that is offered um, through my law school, alma mater Northwestern, and it is a um, a course that involves specifically. I did a course um, earlier in the year on the law and times of COVID-19, and so now I'm doing a course that I'm starting out on Introduction to Key Constitutional Concepts and Supreme Court Cases. So I'll be studying that over the next 4 weeks, in addition to teaching class. So I'm excited about that. But as you know, we are in the midst of a issue involving the United States Supreme Court, where hearings have commenced. Day two was completed today concerning the nomination of Amy Coney Barrett to fill the position that was vacated when we lost one of the most powerful um, people that I know in the United States Supreme Court, and so um, taking that position, and it's very important because it's a lifetime position. As last week we discussed the issue of the lifetime um, Supreme Court justices, you know. So, but uh, but yeah. So, as I said, with the passing of Ruth Bader Ginsburg, um, that meant that the Supreme Court needed one more justice because there are nine, and this president that currently is in office has had the opportunity to select um, two other judges, um, Brett Kavanaugh and Neil Gorsuch. And for those of you who are not familiar with the United States Supreme Court, these cases that they decide um, are very, 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 very important to our society. Yes, we're in the midst of an election, but the Supreme Court justice selection is critical in how the law is going to be interpreted. And since Marbury versus Madison, a case, constitutional law, it has been said that the courts say what the law is. The legislators make the law, and then the executive branch, led by the president. Of course, the other legislative is House and Senate, and then finally the Supreme Court interpret the law. One of the problems that we're having here is that there's an issue about whether or not the Supreme Court is going to get into um, other branches without even saying so. And as many of you know, one of the big issues that's coming up before the United States Supreme Court, I think a week after the election, November 3rd, November the 10th, I believe it is, a case involving the Affordable Act, also called Obamacare, and that the current administration has done everything possible to do away with the Affordable Care Act, and that one of the key features of the Affordable Care Act is that it covers pre-existing conditions. And uh, as many people now know how important pre-existing conditions is, particularly during our pandemic. And so there is a belief that the Supreme Court has not overturned the Affordable Care Act, and in 5-4 decisions, but now the makeup has changed, and it can be 5-4 the other way, or it could be 6-3, but we don't know. But there is a serious, serious concern. And then the final thing about the Supreme Court selection is that I personally, and as a student of political science, that's what my degree is in, and a instructor concerning constitutional law, recognize that the president has the right to select the party that fills a vacancy in the United States Supreme Court. However, those of you who are familiar with the name Judge Garland Merrick, or you should be, you can go back and check when President Obama was in office, and it was nearly a year and a half before the election that um, Anton Scalia passed away. And notice that what happened, Anton Scalia is actually the mentor to the current candidate, who she was a clerk for. And so anyway, what happened, if you recall, is that the Senate, led by Mitch McConnell and also Lindsey Graham, who, by the way, went on record as saying that he would never want to select a Supreme Court justice to fulfill a spot close to an election. And this is much closer, 45 days, when 40 something days when she passed away. And so it left a vacancy, and now there's even a rush that I've never seen in the history of time. And it is a rather alarming thing, among other alarming things that I've seen as a person who studies politics as a political science major and as a lawyer, looking at how the law is applied. And some people say it's about liberal and conservatism. Well, I think that it's about ethics, honesty, and sincerity, and keeping your word when you do certain things. So what I'm saying is that one of the last requests that Ruth Bader Ginsburg made, and was to please make sure that the selection of the next justice is done after the election. They didn't care and don't care, because there is an agenda. So somebody asked me if I thought that if it was Democrats, would they do the same thing? And I said I would hope not. However, though, I'm not going to hypothesize. I could go on facts. I don't have to hypothesize. Facts are a Democratic president wanted to put in a justice. And by the way, the justice was not a quote liberal, but a justice who could everyone agreed would be a good justice. And so you guys are in the midst of that Supreme Court justice selection. You should always remember that in taking this course, you're taking it at a time when we consider it. And with that discussion post that you had this past week concerning judicial review and the reasons why Supreme Court justices are selected for a lifetime, that means that we must have individuals chosen properly. And this is not even a hit on the present candidate, but it is a hit on the methodology that is taking place. And so um, it's one of the bad things that I've run across in politics. But it does involve how individuals in power will utilize the Constitution. And we hope and pray that um, the young lady, Amy Coney Barrett, will get in there and not take away that act, that Affordable Care Act, because I don't care what um, President, um, um, I can't even say it. What the current president is saying right now. You know, President Trump has already not demonstrated a plan to deal with it. He says it's not, but anyway, there's some credibility issues there. And that's not a political statement, that's a statement of fact. That's all over. The other issue involves the 25th Amendment of the Constitution. And the 25th Amendment of the Constitution is an amendment that was put in place to keep the country operating properly under um, good leadership if the President of the United States um, became disabled or demonstrated a lack of capacity to function, you know, the way that the leader of the free world should. And so there have been concerns expressed, serious concerns from medical people, from political people, but I really listen to the medical people. You'll discover as a lawyer that when you are representing individuals, you will lean heavily on medical experts for their expertise for making decisions. And so um, it's it seems to be that there are some things that may be amiss here in terms of that there's some things, you know, if you're bouncing around in your decision making in the same day, yeah, I'm going to do this. Yeah, I'm going to help with the package of stimulus. No, we're not going to ever do that. Then come back again. And that's a scary thing. We don't play that way with that. And I would not want our president, I don't care who they are. And there's precedent where President Reagan and I believe Bush one, think the father, George Herbert, when they underwent colonoscopies, they passed their leadership control of the country to the vice president. And that has not happened here. So anyway, that's a 25th Amendment issue. You want to take a look at it, I invite you to. Constitutional law is a very interesting topic because constitutional law is something that is so important that it controls the life years and years and years and years after the president. Of course, you know, the president can only run 2 terms, 8 years. Senators run 6 years and are reelected. 2 years for Congress, you know. So, but the United States Supreme Court, you're there for life, for life. And so just think about the impact of decisions. There are people who have concerns about Roe versus Wade, the abortion uh, case, and the question of uh, people having rights to determine whether or not they're going to have abortions. Someone once asked me what was my position. I says, I don't mind saying it. I says, I operate on what the law says, and it is not up to me, because actually I believe, quite honestly, in my own position, and this is a religious statement, that the God that I know gives us a free will, and then we have to make our own decisions. Where you can't ram down somebody's throat a situation about whether or not to have a child. I happen to believe that children, I'm against it, abortion. However, I understand what's being said on both sides, and this is a like I said, these are some major decisions with the Affordable Care Act and with Roe v. Wade. Then there's some issues that are in a mist, because I study about what's happening in the Supreme Court, voter rights cases. And I look at those very carefully, because I am 70. I remember when there were poll taxes. Yep, it is all up to the individual, and that's my whole point in a nutshell. Because the fact that people ought to be able to do that. Because here's the problem that we had, just so you guys know, you guys are younger. Before Roe v. Wade, there were, and then even after that, there were illegal abortions, and it caused um, serious injury to people, and you would lose both the baby and the mother. So there's some issues. They say, you're a pastor and you support Roe v. Wade. I didn't say that I supported Roe v. Wade. I said exactly what Braille has said. I think I said her name right. I tried to say it right. I talked to her a little while earlier today. Um, the the point, yes, okay, thank you. What Braille says is that it's important for people to be able to, as my grandma used to say, every tub got to stand on its own bottom. And what that means is you can teach your kids right from wrong, but when they become older and they depart, they got to make their own decision. But as I'm a believer that yes, yep, I do pray a lot. Yes. And I certainly believe not in imposing my will on people, but just stating some things. But what I don't like, good people, is unethical people. I believe that people should, in high positions, should be able to speak and say what they mean and mean what they say, and then we can rely on it. Now, should they change their position, they should come back with some rational basis supported by the reason that they made the decision in the first place. And then it's just like I tell you guys when you do your papers, include critical thinking. Don't just make a statement about something. But so anyway, yeah, uh, yeah. My kids say my dad knows, say what he mean, and he means what he says. And and then I say that to my students. I said the 25th hour of the day is the only hour you can't call me, and I said what I mean, and I mean what I said. Very simply that. So anyway, in the context here, and this fits, this is not like somebody says, okay, it's class. I said, this is class, what I'm talking about. I'm talking about constitutional law and the impact that we have. And then, like I said again, how do you express your position about what you don't like? The way that I do. I vote and I peacefully protest. But my job is I am in the public. I'm part of the media. Actually, people didn't realize that, but I really am part of the media, and I pay close attention to what um, is reported in the news. and operate on the basis of fact. I was taught in law school, Mr. Wright, if you're going to open up your mouth, live up to your name. That's what one of my professors told me. And I said, okay, good thing my name wasn't Mr. Wrong. So, all right, guys. So, keep your eyes on that. Study it. It's something that will be beneficial to you as a lawyer, as a law enforcement officer, in our criminal justice system, which, by the way, our criminal justice system needs, as they say, some work. It's kind of operating on a resuscitator, and it needs good people. And I see right now in front of me, um, 5 really good people that, I believe, uh, 2 of you I know, um, and 1 of you I know pretty well, and I based that on my previous students. So let's let's get roll up our sleeves and let's get about that business. So okay, guys, let's see where we are this week. Are in week 2. Let's share my screen. Okay, here we go. Okay, few of you have reached out to me about, the lecture, how to find it, all the way down, like I'm rolling right now, under the rubrics, which I'm going to come back to in just a minute. Here it is. It says live classroom session information, and it gives the link right up top to the live lecture, which you can copy and paste and onto your browser, and it will take you right into this classroom here. Um, and so that's what you use in all of my classes, whatever classes you take. And of course, our lectures are roughly 8:30 to 9:30, and on Tuesdays. Now, be aware we will have a lecture on election day. Um, that will be actually, that will be uh, week 4, I believe it, or week 5, one or the other. I think it's week 4. And so our lectures will take place every Tuesday, except week 6 lecture is going to take place on a Thursday. So you're going to have 2 lectures. Yeah, so, okay, it is. Um, you'll have a lecture election night for week 5, and then 2 days later you'll have a lecture for week 6. And the reason is because the course will end on the 10th. And our recordings each week will be down here at the bottom. So you could actually click on the link that you have here, and it will take you to the lecture, which is a YouTube. Okay, so now let's go back. So week 2, briefing a case, which reminds me, I got to send you something that I didn't send you. That was, don't try not to get started too quick on briefing a case until you get this information I'm going to send you. But there's also some stuff in the module as well. But I'm going to send you something right after we complete the lecture about briefing a case. Briefing a case is very, very, very important. And you want to make sure that you provide answers to each of these sections. Very important. And you're going to have to make sure that you understand that, well, you're not going to have to deal too much with APA format, because a brief in itself has a special format that you're going to follow. And you're going to make sure that you get that to do your 80 points. I'm going to go over that in a little bit. So that's the written assignment that's due Sunday. And then your course project. This week, you have one of the easiest parts of this assignment, and that is select a topic related to the Fourth Amendment and explain why you chose that topic. And then if you are going to provide some information that make sure that you cite the source that you provide that information from, and then provide a reference. Make sure you have cover pages for these items as well. So we're going to talk about them in detail. So now let's go over to well, before we do that, let's do this. Let's go to the course calendar. Okay, there it is. And it tells you right where we are here, the 13th. You have 2 initial posts that are due this week. And the initial post is due tonight. Your reply posts are due Saturday. I do want to remind you that you need to do both discussion posts in order to get full credit, and you'll lose a lot of points if you don't do both of them. And then, of course, you see your live lecture here, and then you see, of course, you see your reading assignment that was given, Chapter 4 and Appendix E. I sent you the PowerPoint for Chapter 4, but Appendix E of your textbook really doesn't have a PowerPoint, but you want to make sure that you use that as well this week. And then your written assignment that I just mentioned. No, I don't want to delete it. Your written assignment about briefing a case, and we're going to talk about that in a minute more. And then select your Fourth Amendment topic. Okay. All right. Very, 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 very important. Okay, your Fourth Amendment topic. All right, so now let's go to back to the course. Let's make sure that we look at the announcement. This is another place. Oh, by the way, I just mentioned the course calendar. That's a place also where you can find a link to where the lecture takes place. So we're going to talk about equal protection under the law. Equal protection under the law, and I'm going to talk a little bit about that as well, and how that's a relative term, unfortunately. And you'll see what I mean when I go over that in a few minutes. Chapter 4 of the text, Appendix E of your textbook. And then equal protection under the law and briefing a case. So that's some information that you're going to have that we'll go over before we adjourn tonight. And here's a discussion assignment. Is it really equal? That's the question. Is the equal protection under the law really equal? Is it? Then you deal with the topic of prisoner equality in the other posts. Very interesting posts that are involved in each week. Briefing a case and the Fourth Amendment project is written assignment. So the Fourth Amendment project is the second one. And then I've already shown you the rubrics there. And you already know what adversity is, the springboard to success is all about. Those of you who've been in classes before me, excuse me, know all about that and know where I stand on that. It's not hypothetical, it's based on real life stuff. Okay, so let me collapse that. Let's go and look at what we have here. So the course project is look up the Fourth Amendment. You should be aware that the Fourth Amendment is one of the most used amendments in the Constitution. It is the amendment that's usually referred to as the Search and Seizure Amendment, the Right to Privacy Amendment. Those are just a couple of the names. And there are many cases, many cases, many cases that you can find. And then so what I want you to do is look at those cases. And then after you've reviewed the amendment and what it stands for, what it says, then pick an area. Pick an area within the Fourth Amendment. Now, the Fourth Amendment deals with search and seizures, but there are areas such as stop and frisk. There's other issues that involve the Fourth Amendment. Stop and frisk. Everybody know what the famous case that involves stop and frisk? Anybody know? Type the name in. Let's see how ahead you guys are. What's the name of the famous case? Anybody know? Too late. Terry versus Ohio. Terry versus Ohio. That's the case, and you'll be able to learn more about that case. But that's the famous stop and frisk case. And so then you're going to write a one-page paper indicating what area you've chosen and why. Don't give me a little short thing. Give me one full page with citations and references. If you're going to mention some cases, cite those cases appropriately. Make sure that you use the format properly to cite your cases. By the way, you'll see Justia and you'll see Oye. Those are not the appropriate citations. The appropriate citations, and try to stick with United States Supreme Court cases. Generally, the United States Supreme Court cases using the official involves a number, and then it'll say US, then it'll say a second number, and then in parentheses, it will say the year. So what that means is the volume number, let's say volume 100 of the United States Supreme Court reports, and then the number that's next is the starting page of the case, and then in parentheses is the year that is done. Now there are ways of doing it. There's a method utilizing Westlaw, West citations, but try to stick with the official. Try to stick with the official. You'll be better off. It's easy for you to find. You can Google a case and find that information out pretty well. That's going to be one of the things that I'm going to be reading when I read your briefs. So one page. So this is very simple. So yeah, yep. Well, in Blue Book citing, those of you who are paralegals or paralegal students, some people don't know about Blue Book citing, but yeah, Blue Book citing actually teaches you to cite cases because you guys are being prepared to write memos and briefs. Am I right? Right? Yeah, the answer is yes, though, because I was a law clerk, and we didn't have any formal training. I taught myself how to do it, but yeah, uh, when you cite appropriately in there. But I believe, if I might be wrong, but I think I'm right. The APA 7th edition also, I think, provides how to appropriately cite cases as well. And there's no conflict in terms of citing cases and statutes, and that's the key thing. So okay, so now that's what you need to do for that. Any questions about the course project? Okay, I'm going to talk about um, okay, all right. I love it when you say you got it. So I've already given in, and you see that it is due this Sunday for 100 points. Let's shoot for 100 points. I love when I get through grading all my papers and I see a bunch of hundreds. I love them. I get excited. I celebrate. Okay, you know, and I encourage you to do that. Get into that mode. Okay, and then briefing a case. Did I not ask you about this case? Did I mention this case earlier? Okay. That's why I thought somebody was going to tell me about the stop and frisk case, because it was an assignment. I was just holding. So, but some of you, have waited until this time, but that's cool. So you see what I'm saying? See what I'm saying? It's the name of the case, Terry versus Ohio, which when I said citation, I should have mentioned the fact that it has to have the name. But it's Terry, or the name, versus whoever the defendant is, and the state of Ohio in this case is. And notice it's 392, which is the volume of the United States Supreme Court publication, U.S. I don't care if you miss. Some people are very dogmatic about the .us. I'm not. I'm not that dogmatic, but I mean, I try to be a perfectionist, but I don't hold my students to a standard sometimes that I am, because I'm a lawyer and I went to law school. So far as I know of, nobody in any of my classes I've taught here at Rasmussen University, by the way. Yay! You do know that as of the 13th of October, which is today, we are no longer Rasmussen College. We are now Rasmussen University. That's exciting, guys. That is so exciting. I mean, I've been here 9 years, and I'm excited. I remember when another school called Robert Morris changed over from a college to a university. I remember when those of you who are here in Illinois, right here, College of St. Francis down in Joliet was called that, and now it's St. Francis University. But because of things that we're doing, we fit the mode of a university. And so guess what? You will have on your transcripts when you graduate and your diploma, hey, Rasmussen University. I am so just, I beam about it, because I'm a part of that development. I've been here long enough to have 9 years, and just celebrated my anniversary the other day. And so I am just, uh, I'm excited, guys, as you should be as well. So when people ask you, where do you go to school now? You're gonna say Rasmussen. No, it's Rasmussen University. So you can say Rasmussen, formerly known as. So yeah, it is. It is. It really is exciting. The signage and all of that they just released to us, steps that they're going to take, but that officially the 13th was the first day, and then signage is going to change. They're even getting us new business cards. They gave us during the summer university shirts, which we were able to wear several times, and you know, um, I'm just excited. So anyway, okay. So you have these assignments. Briefing a case. Follow the directions for briefing a case in briefing a case page. Now, the information I'm going to send you doesn't supersede that, but it actually helps you supplement it. And there are things that are very, very, very important, and we're going to talk about that in just a few minutes. Okay. So now I'm going to withhold questions about briefing a case until we do that portion of the lecture in just a few minutes. Hey, those of you who are paralegals, paralegal students, have had paralegal training, you know already about briefing cases, don't you? I know you do. Did any of you have Dan Walker as a writing instructor? No? Kirk Olson? Yeah, that's my buddy too. Well, Dan Walker is a former classmate of mine at Northwestern Law School. His dad was the governor of Illinois, and I was one of his supporters years ago. So Dan works for the school. I think he's still an adjunct. I haven't seen his name surface lately, but he's done it. But anyway, the point I'm making is that, and so, hey guys, we have two very three three very qualified individuals in this class who can help you if you set up tutoring sessions. Uh, okay, you lost your connection. Okay, did you get it back? Ashley, did you get it back? She must not. She didn't say it. Okay. So I'm going to tell you, it says peer mentor in our class. It's not she's hiding her identity. It's just that the system won't let her change her name. So it's Ashley. And Ashley and Cynthia and Melissa. Those are the three that are in this class that are, and I've had Melissa in a bunch of classes. I lose track of how many classes I had her in. In fact, I thought she was already gone, but Melissa keeps coming back for more. She must really like something that I'm doing or something. I don't know what it is. No, but seriously, I work hard with my students, and they all know I care. But we're fortunate, and I told Bethany, by the way, that, and those three know who I'm talking about, their boss, that I was excited about having you three in this class, and that this should be a high performance class because you got a professor and three student students, can't say student, I can't talk, student peer mentors, and are here to help you. So if you go to the tutor section of your course, you can set up a discussion within one of them. Um, but I don't know if you'd end up with one of them or not, because I think that when you submit a tutor request, you don't request the name of the tutor, or can you pick the tutor? I'm trying to remember. Help me out, guys.
You can pick the tutor that you want. They would just have to select like Blue Book, or they would have to select a paralegal course, because being we're in the middle of this course, we're not allowed to tutor this course.
Right.
So they would have to select Blue Book, and then
Yeah.
they would have access to all of us tutors, and they can select whoever.
Okay. The other tutors who are not in this course that can help though with them, right?
Yes, they can still help.
Yeah, and that was my understanding too. So, and I kind of told students pretty much that thank you, was that Cynthia?
It's Ash.
Oh, Ash. Oh, okay. All right. All you guys, I love you guys. Cynthia is one that sticks with me tight, 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 because my second sister's name is Cynthia. So I've been saying that name for 69 years. Okay. So, but anyway, I'm glad about it. And so you guys now heard that that are in the class, and then those who will hear the recording. But I feel blessed and just count it a privilege to have those guys.
Can I just clarify? This is Cindy or Cynthia. The
Okay.
tutor has to have already taken this class and passed it with a B or higher to tutor in this class.
Say that one more time.
Okay, the tutor has to have already taken this class and passed it with a B or higher to tutor in this class.
Okay. All right.
For the briefing a case, with it being Blue Book, the students can book a tutoring session with a tutor that is a paralegal student or, paralegal tutor to be able to go over briefing a case.
Which would be, I was just getting ready to say, which would be very, very, very valuable for this week's assignment.
Yes.
Awesome. That's, you know what? See, I'm spoiled. Okay. All right. I'm sticking my chest out. Okay. Yes. Yay. All right. So I thank you guys for saying that, because there's some stuff I didn't know, but I wouldn't know unless I go to the experts, and I consider you guys the experts. And like I said again, it's awesome. And so you guys in this class heard that, okay, and you know how to operate on that basis, okay, for this assignment. I'm going to provide you with information, but they know, okay. Now, and the reason why, by the way, that they're able to do that, even though they're taking this course, is because that's what the paralegals are trained to do in paralegal training, how to write memos, briefs, things of that nature. When I was a paralegal, quote, law clerk, I taught myself how to write memos and briefs. And actually, let me tell you something, guys, so you know about briefing a case. That lawyers use briefcases. It sounds funny, not the things they carry, but cases that are briefed to utilize arguments in courts. And when they submit memoranda of law to the judges, that judges often rely upon to issue opinions that are written in the majority, in the concurring, in the dissenting opinion, which, by the way, I'm a big fan of dissenting and concurring opinions, because that's where new law comes from. But it's so important. We were taught at our law school to pay close attention to those, not just focus on the majority, but the concurring. And the difference between them is that the majority is what it means. So in the case of the Supreme Court, United States 5-4, that means at least 5 participated in the majority. But maybe 4 might have participated in the dissenting and or concurring. When you concur, it means what it says. I agree, but you may have different reasons why you agree. So you're not totally on board of 100% of the majority. And then the dissenting opinion is the opposite of what the majority decision is. And it is not something that people should ignore, because dissenting opinions become such as years ago, the case of Plessy versus Ferguson, that said separate but equal was once the law of the land. All right. Well, there was dissenting opinions in Plessy versus Ferguson that said that that's not correct. And then finally in 1954, the famous case of Brown versus the Board of Education, which said separate but equal is not the law anymore, actually overturned Plessy versus Ferguson and made it the law of the land. I'm just giving you an example of how those things operate. So, all right. The discussion is it equal? Okay. Basically, the question is, there's the equal protection of the law. And the question is, are people treated equally under the equal protection law? And you're going to ask, is it fair for people to be treated unequally under the equal protection of the law? And then how can the legislature go about making it more equal, balancing the playing field? The figure that we use is the scales of justice, which are supposed to be a scale to equal when you got proper balance on both sides, not one side heavier than the other, but balanced equally. That's what it means. So make sure you put some good ones in. I'll be looking at those. And then prisoner equality, equal protection comes up in prison right cases. And you know, there are a lot of petitions in prison cases. I have a friend who was a lawyer for the state, and he dealt a lot with petitions that were submitted by individuals that were saying that their rights were violated, such as 1983 cases. That's a section of the United States Code, which is the statute for all laws in the United States of America. But anyway, not that section, but anyway, the United States Code is. And that there were petitions that were filed, and some were frivolous, and they set up a law to eliminate frivolous lawsuits. So anyway, deal with that as well. And then your live classroom lecture. Okay. So that's the assignments for the week. Okay, now let's come back here and let's go to the lesson content. And let's just go down to, let's come back to equal protection in just a minute. We'll come back with that. But briefing a case, here is what you're going to be doing with briefing a case. And your title, Miranda versus Arizona, the citation, and we already talked about that. You're going to have headings that have these areas, and I encourage you to make sure that you provide these headings. It says, do not copy and paste from another source the facts. Restate the facts. And I run your papers through Grammarly, by the way, and it will tell me. List what happens in the lower courts. Just a few details. Issues. What's the issue or issues facing the court in a way they can be, and issue the question so they're answered yes or no. The answer to this section is not yes or no. You got to elaborate on it. Just like here, the holding. How did the court issue the question? What did they do? How did they resolve it? Yes or no? Did they deal with the issues? Yes or no? And elaborate on it. Explain yourself. Don't just say, I have a lot of briefs I get, and then yes or no, yes or no. I said, that's not sufficient. And if you talk to our people in this class that can help you with the Blue Book issue, they'll explain that to you as well. Reasoning, the most important section, explains how the court reached this conclusion, and the reasoning behind this holding up here. If the law is changing, explain that too. I already explained, provide you with one example of that with Plessy versus Ferguson. Concurring, I talked about that. Only include this section if you believe there's a concurring or dissenting opinion is important. Listen to me, hear me well. In terms of these decisions, you will see it in most cases. If you don't see it in the case, by the way, this case, that not Miranda versus Arizona, because that's not the case. You know the case, right? Mapp versus Ohio. And so in there, you will find both of these, and they are important. I'm just going to tell you that up front. All right. All right. So it's very, 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 very important. All right. So now, talking about the course project. here are the due dates for the course project. Okay, this week, introduction to the topic. All right, now select your topic. Then you're going to do in weeks 3, 4, 5, and 6 these things, and we'll be talking about them. Okay, so each of these are evaluated independently based on the rubric, but I will also talk about them. So you don't have to worry about next week right now. Worry about this week. Okay, so choose an aspect of the Fourth Amendment, research the surrounding cases, and those kinds of things. All right. Any questions so far? We're at time, but I'm going to go a little bit over. Okay. So now let's conclude by talking about the Equal Protection Clause. And here it is, right here in front of you. Notice the first word. What's the first word? Yeah. Can anybody tell me, does all mean some or does all mean all? It means all. Yep. All. So it says, and I got to read this because sometimes hearing it gets into people's spirit more. All persons born, so far as I know, every person that I met has been born. Okay? It says, or naturalized in the United States. So now what it is saying here basically is that all people who are born citizens of this United States or naturalized, that means that at one point you were an alien and then you became a citizen of the United States. And subject to the laws or the jurisdiction are citizens wherein they reside, in the state and where they reside. Now, we know that there's some areas about where people reside. Like, for example, take Trump and Pence. What states do they reside in? Anybody know? Anybody know what state President Trump resides in? Nope. I don't think it is. Yep. I think it's New York. I think it's New York. I know that it used to be. I doubt if it's any different now. Well, what about Pence? That should be an easy one. That's okay. That's easy to happen though, because there's more emphasis on Florida for the president. What about the governor? I mean, what about, see, I gave it away. What about the vice president? Anybody know what state? Nope. He's not from DC. Yep, that's correct. He was the governor of Indiana, which my wife didn't know that. And she said, really? I said, yes, he was. And so that's where, and if you heard him, if you listen carefully to the things that have been going on during this campaign, that he was talking about, do you remember a week or so ago, he was talking about he was going to go to vote in Indiana, but something happened and he didn't end up doing it at that time. Anybody remember hearing that? Well, anyway, he was a governor of Indiana when he was selected by Trump as his running mate. So back in the beginning of this whole thing. So anyway, so in the state where you reside, Um, Students have the same issue a lot of times. Like we don't have it so well. We don't have it so much here at Rasmussen because of the kind of school we are. But schools like my alma mater, Northwestern, or some other schools where you live in another state, but you go to school in a different state, then usually you reside in the state that you came from, where your parents lived, or where you actually lived. So you can only have one, by the way. So that don't mean you can vote in two states. That'll be illegal. So it says now the states, listen to me. So now you're entitled to equal rights in the jurisdictions that you live in. No state means what it says. No state that abridges, that is, takes away the privileges or immunities of citizens of the United States. That's what it says. Nor shall any state deprive any person of life, liberty, or property without due process or law. And what that pretty much means is that you can't lose your property. You cannot have items seized. There's some special exceptions, but most of the time you can't. When you start talking about things like the Patriot Act, but in the general course of the law, you have a right to a hearing. You have a right to confront witnesses and to provide. So we don't just take people off the street and they're guilty. No, you either have to plead guilty, or either you're found guilty by a judge or jury. And so you have you can't be deprived of life. And by the way, that's why unjustified killing or excessive force cases with law enforcement apply in terms of depriving a person of life. Liberty without due process of law. In other words, we don't operate on vigilante law. We don't operate we are all able to apply the law without due process. No, that's not correct. Nor deny any person within this jurisdiction equal protection. So now we come back to the point at the end that says all of those things that are said contextually should apply. But as you know, and I know, that there are things like what we're talking about here, and I'm going to try to go through these two as quickly as possible. Forgive me, it's a couple minutes over. If you have to go, I understand, but I want to try to give some light on it. Jury selection and racism. The law is quite clear that a person should have the right to be tried by a jury of their peers, and that we lawyers are familiar with what we call peremptory challenges. These are challenges, and they give us a certain number to remove jurors that we don't want to be on a trial. And when we do that, we are supposed to use them any way we want to. You know, I don't like the way that person, their karma doesn't seem right, or that. However, one of the things that we cannot do is to remove that person based on solely their race. Now, that's when we run into the problem, good people, the conscience of the individuals who represent the parties. Unfortunately, the application of peremptory challenges do end up based on the basis of race and sex and national origin. I'm just telling you, that's just how it actually breaks down for real. However, it says, notice what it says, may not be removed from service solely. If you turn around and say, I don't want black jurors, then you bam, you need the crap beat out of you if you're somebody's lawyer, because first of all, number one, you said something you shouldn't have said, which is racist, and our system doesn't like overt racism. Our system, however, unfortunately, operates under covert racism. That is systematic racism. I don't care. The president and vice president has been asked, is there systematic racism in the United States of America? Yes. But we want to fix that. So what we want to do is bring it back to apply the equal protection clause and principles. That's what we really want. Somebody said that's idealism. Well, I can say this to you. We can try to use that as a basis. So let's just take this language that regarding the equal protection under this Baston case, which came in 1986, and that was 20-something years after the Civil Rights Act of '64. The same equal protection principles as are applied to determine whether there is discrimination in selecting the veneer, which is that's the panel, the state's use of peremptory challenges to strike individuals from the petit jury, or as the jury as you know it, although a prosecutor is ordinarily entitled to exercise peremptory challenges for any reason, as long as that reason is related to his view concerning the outcome of the case tried, the equal protection clause that you just read earlier in the 14th Amendment says that the prosecutor, it forbids the prosecutor to challenge jurors solely, that's the key word, solely on account of their race, or on the assumption that black jurors as a group will be unable to impartially consider the state's case against a black defendant. It reminds me of something that President Trump said, which was racist, that it was a case that involved his business. And he said because the person was of a certain ethnic group, I think it was, I can't remember, but it said that the person wasn't qualified to do so because they were biased. And Latino, was he? Okay. But anyway, that's outright quote racist. I mean, you know, even it's ludicrous. So anyway, the point of the matter is Baston versus Kentucky makes it clear that race is one of the things you cannot do it with. Now, we still are waiting to hear how the case would extend to age, to gender, and to religion. But it's interesting, good people. You should be aware that, going back to what we talked about earlier in this lecture today, that it's going to depend on the makeup of the court and how the judge, and see, justices kind of tip their hands because most justices, were appellate court justices before that. And then, of course, they are questioned during Senate hearings about the selection process, how they feel on certain issues, and they are to give honest answers to that. So anyway, the point of the matter is so the jury is still out, and I say that just using the term, the law is still out on age, gender, and religion, and we need to keep our eyes open for that issue. So finally, I want to conclude with talking about the fact that is there discrimination in criminal justice? I'm not going to ask you to answer it. I'll do it for you. Yes. And it starts with issues like racial profiling. I have been racially profiled. I have. And it wasn't long ago. And I haven't been incarcerated, but I've been stopped because of my race in an area where I lived. I don't live there now. I don't live far from there now. So the point of the matter is the numbers, as they say, the numbers speak to it. We learn as lawyers, the evidence of numbers. Now, sometimes, like for example, surveys, the answers for facts depends on who you question. And survey of local jails of all jail inmates, blacks 38% and Hispanics 16%. These percentages remain nearly stable until mid-year. Now, the thing that I don't like about this particular survey is that it's actually not correct. There are really more blacks that are incarcerated than whites and other minorities. But the point of the matter is, it depends on who prepares the surveys and who does. It's just like somebody asked me about what is that thing called? What they rate what you watch on television. I forgot what that thing is called. Nielsen ratings. I have never been a person that was reached out. Oh, one time about a Nielsen rating, about stuff like that, you know. But they also have these all the time. But anyway, so be careful about surveys. So in a survey of 40 urban communities across the United States, 62% of the juvenile defendants were black, 20 were white, 16 Hispanic, and almost 2% of another race. That kind of may be closer to what really is what's taking place in not just in juvenile, but in adult courts. So anyway, it's based on some of the statistics or data. But anyway, I'm going to go to the last thing and then I'm done. It says, according to U.S. Department of Justice, the racial disparity for judges across the United States is extreme. Boy, do I know this one. For example, in 2004 in Wisconsin, there were 240 circuit court judges. 229 were white and only 6 were African American and 3 were Hispanic or Latino. So you have to understand that's the same thing we talk about in terms of law enforcement statistics about the selection of individuals. There needs to be a balance. Remember, people, going back to the fact that we are in a diverse world and that people approach life differently, and that there should be people that, I'm not saying that just because you are a certain minority, you should be, they should only have those individuals dealing with it. But there should be enough of a balance of people to represent the proportion or percentage of the community in which you live. So anyway, that's the way, and the way the law operates, that's the way it is. So anyway, that's it for tonight. Good night, guys. Equal protection is the key phrase for tonight. Give me that, and you got your points. I thank you guys for hanging in there. I appreciate you. Again, tonight's topic, because I spent so much time talking about the contemporary things, which I think are important for students to think about while taking these courses. So you see that what you're studying in your assignments are relevant to what's happening around you, and you need to be prepared for that. So, well, good night, guys. I will see you. Thank you, guys. Thank you, Cynthia. Thank you, Ashley, and Chris, Latoya, and Brielle. She had to leave earlier. I know why, but I will see you next week, Tuesday at 8:30 p.m. Central Standard Time. In the meantime, if you need to reach out to me, look out for this email that's going to be coming right after I get off of this call. Good night, guys.